This case is being dismissed because I asked to be heard.
I do not believe that the middle finger was shown in the video.
So the video does show the middle finger is raised and the items are dropped into the trash bin. There is a prima facie case. A move to dismiss that could be deemed to be in bad faith.
A judge is about to let a domestic violence case disappear until she asks one question the prosecutor cannot answer. Her name is Sally. Her ex-husband is on trial for grabbing her clothes, hauling them down the stairs while she filmed him and dumping them into a trash bin. But that's not why this case matters. What matters is what happened next. Twice, the district attorney's office tried to walk away from this case. Twice, they nearly succeeded. And when Sally stood up in that Colorado courtroom to speak, both the prosecution and the defense agreed on one thing: she shouldn't be heard at all.
Judge Kazy, I did want to object to the dismissal. I did want to ask the court not to grant it. That being said, I feel very scared being in this room and speaking in front of my abusers.
This is the story of what happens when the system meant to protect a victim decides it's easier to protect itself. The case begins with an allegation that sounds almost mundane on paper.
It is one
Does he say that he's going to destroy her property?
He says that he is going to put it in the trash can, in which he did. It appears that he put it in an empty
Sally's ex-husband, identified in court as Mr. Schieffer, is accused of second-degree criminal tampering and an act of domestic violence. Criminal tampering means interfering with someone else's property with the intent to cause harm or inconvenience, a charge that sounds minor until you understand the context. This wasn't a random dispute over belongings. It was, according to Sally, one incident in what she called an ongoing cycle of violence, one that had already produced protection orders and mandatory psychiatric evaluations in the past.
I can keep on track.
Sure.
The reasons I'm feeling this way is this is an ongoing cycle of violence. This is not the first time that I have either reported or Mike has been charged. The past incidents have resulted in protection orders for me and my children and mandatory psychiatric evaluations. Mike is a manipulator. He has a history of violent and vindictive behavior. Since the most recent incident where there is a protection order in place, he has still tried to contact me multiple times, and I have tried to report it. Tried to report it to the Vail PD, the Avon PD, and the Eagle PD.
And despite that protection order, she said he had filed a letter with the court that began with the words, "Dear Cutie," sent to her directly through the court's own filing system.
Who they should send it to. He's even filed a letter with this court where it starts, "Dear Cutie," and he tries to get me to dismiss this. And
Wait 1 second. So hold on. So there's something that was written to you.
The letter that starts with "Dear Cutie" that was filed with this court and sent to me via the e-filing system despite having a protection order.
Read that again. A man under a protection order, using the machinery of the court itself to reach the woman it was supposed to protect. Sally said she tried to report it to 3 different police departments. Each one declined jurisdiction. One detective admitted the letter showed clear intent to harass, but said it wasn't his department's case to take. Nobody wanted it.
Order.
We did attempt multiple times to file police reports about that. Avon declined, Vail declined, referring us to Eagle, who did not return repeated phone calls to take a police report.
Detective Zepeda at the Avon PD said it had a clear intent to harass, but that it wasn't his jurisdiction, and also said that it wasn't like I'd been punched in the face, but not to let that deter me from reporting in the future. My concerns with dismissing this are that he's going to do what he's always done. He's going to play nice. He's going to fool everyone and return to violent behaviors. I'm very scared for my
That's the pattern here. The abuse survives not because anyone denies it happened, but because everyone insists it's someone else's job to act. Think about how often that happens outside a courtroom. A complaint at work gets passed from manager to HR to someone else's desk, and by the time it lands anywhere, so everyone's moved on but the person who reported it. Now the villain of this story enters, not through accusation, but through his own words.
Well, I believe the district attorney has a motion to dismiss, and it sounds like Mr. Ryan, on behalf of the victim, wants to make a statement, which I know they're entitled to do. So Mr. Schaefer doesn't have any objection to a motion to dismiss, and are grateful for the discretion that the DA has shown on this case.
Ultimately, I do believe is the intention is to dismiss this case.
Prosecutor Mr. Powell moved to dismiss the case, telling the judge the district attorney's office cannot prove the charge.
This case. So if we can just get this set over, I would say for the shortest period possible.
Mr. Powell?
That is correct, Your Honor. The people are moving to dismiss this case as we cannot prove the charge of domestic violence criminal tampering 2. There are issues proving the intent piece of that, as well as the fact that it appears to the people that this case is being used by both parties in their ongoing divorce case.
He said there were problems establishing intent. He suggested the case was being weaponized inside an ongoing divorce. And when Sally stood to object, her own words became the pattern interrupt no one in that room expected. I feel like this case is being dismissed because I asked to be heard.
And I'm worried that without a conviction, this is going to continue to happen again and again and again. I feel like this case is being dismissed because I asked to be heard.
That sentence stopped the room because it wasn't paranoia, it was documented history. This was the third prosecutor to handle her case. The first deal collapsed, she said, specifically because she'd asked to be present. The second prosecutor offered probation, which the defense rejected. Now a third was trying to make the whole thing vanish.
Mike accepted 24 months probation with DA Alicia Brisson, and that wasn't tendered when he accepted that because I had asked to be present and to be heard. The next time we met, DA Brian Powell offered him 18 months probation, and him and his lawyer declined. And now DA Powell is saying that he's not going to move forward.
Here's where the hero of the story steps forward, not Sally alone, but the judge herself, Judge Kazy. Before ruling, she asked to see the video evidence Powell claimed was too weak to win at trial.
I do not believe that the middle finger was shown in the video. There is a motion he makes, but I don't believe it was a middle finger. Other than that, the content of the video is roughly what is in the warrantless affidavit. If the court would like, I could pull up the video and show you.
Why don't we do that?
What she saw contradicted him directly. The footage showed exactly what the affidavit described, including the middle finger gesture Powell had insisted wasn't there. The video does show and state exactly what is set forth within the affidavit, she said.
So the video does show and state exactly what is set forth within the affidavit, and the middle finger is raised and the items are dropped into the trash bin. That exactly corresponds with second-degree criminal tampering and an act of domestic violence. There is a prima facie case.
In domestic violence law, prosecutors carry enormous discretion to dismiss cases, but that discretion isn't unlimited. Under Colorado Revised Statute 16.5.209, a judge can compel prosecution if a refusal to proceed is arbitrary and capricious, meaning without reasonable justification.
Sure.
Under Colorado Revised Statute section 16-5-209.
16.5.209?
Yes, Your Honor. The court may compel prosecution only if the court finds that a refusal is arbitrary and capricious. I feel that this is not arbitrary and capricious, and if I am misunderstanding that statute, please tell me. However, I do feel that that statute is directly on point here.
So this is when a judge can require you to prosecute, but is there a specific section relating to not accepting the disposition of dismissal?
Judge Kazy found exactly that. Powell doubled down anyway, arguing that under a precedent called the Gant case, victims have no right to address the court on a motion to dismiss, only a right to be consulted privately by the DA's office.
I understand, Your Honor.
I read the pleading about the belief that you believe at critical stages, which this is, you don't believe that the victim has a right to be heard. Is that accurate?
The judge dismantled that argument in real time. I have never had a circumstance, she said, where an attorney has argued that a victim must be silenced in court. That's the moment worth pausing on. A prosecutor whose job is to represent victims, arguing in open court that this victim had no legal right to speak.
That is what the Gantz case says, Your Honor, and it's good law. It hasn't been overturned, and I think basically what Gant says is the victim absolutely has a right to be heard. It just isn't in court. It's the right to consultation and the right to be informed. And those conversations occur between the DA and the victim. And it's the DA's job to tell the court that they're VRA compliant. And they can inform the DA can tell the court that, the victim opposes it, but to allow the victim, it's not a sentencing hearing where the court needs to know that, the victim's not under oath. It's not a sentencing hearing where the court is going to sentence the defendant based on, the victim's experience.
So
and
in that case, the issue was the victim may not, present a pleading opposing dismissal. That's not what happened at the last hearing was the victim has a right to be heard, and the victim states their feelings, which I have never had a circumstance where an attorney has argued that a victim must be silenced in court and doesn't have the ability to speak at a critical stage. And you are conveying that you believe that to be the state of the law under Gant specifically.
So, does a prosecutor's professional judgment about winning a trial outweigh a victim's right to be heard in the courtroom deciding her own case? That's the question this hearing forces into the open, and there's no clean answer.
And it met it to a T. Then Mr. Powell told me that the reason that he wanted to dismiss a case is he thought he would have trouble at a trial. Here's what happens in domestic violence cases. They are messy. Your victims don't come perfect. But if you can establish by looking at a video the exact elements of a criminal offense, then the move to dismiss that could be deemed to be in bad faith. When you dismiss a domestic violence case, it also
The climax arrived when Judge Kazy delivered her ruling. She denied the motion to dismiss.
So I understand that pretty much everyone sitting here today disagrees with the ruling of the court, but sometimes the court has to make its own call. And the call that I've made is to deny the motion to dismiss. I still deny that today. Want to make it
Not
clear.
once, but twice after Powell pressed again. She acknowledged both sides disagreed with her, prosecution and defense alike, and ruled against both. I still deny the motion to dismiss, she said. I firmly believe that in domestic violence cases, there has to be more careful scrutiny. It was by her own account, so ruling she had never issued before in exactly this way.
Appropriate arguments. Having said all of that, I still deny the motion to dismiss. I've never had a situation where I've now disagreed with both parties and done something completely different. But here I am. And I believe my decision's correct. I'm still making that decision because I firmly believe that in domestic violence cases, there has to be a more careful scrutiny over dismissal of these cases, especially when we have a video that outlines exactly what actions with specificity meet the elements of the crime charged.
could we just get a 2-week continuance to figure out what to do next? Thank you.
July 6th.
But here's the incomplete justice the story leaves behind. The case wasn't resolved that day. It was continued, pushed forward into more hearings, more motions, more chances for the same pressure to resurface. Sally won the right to be heard. She did not win a conviction, an apology, or a guarantee that the next prosecutor won't try the same maneuver again. The system bent. It didn't break. What this case teaches is simple, even if the law inside it isn't. Process exists to protect the vulnerable, but process only works when someone with power is willing to enforce it against people who'd rather look away. A judge did that here. It shouldn't take a judge willing to disagree with everyone in the room for a victim to simply be heard. If you want to see how this case ends, or which courtroom confrontation we should break down next, tell us in the comments. Subscribe and share this video. The more people understand how these decisions actually get made, the harder it becomes for anyone to make them quietly.